And I want to again express how honored and privileged we all are from the United States coming to the National Law School at India University. For some of us, like myself, it's the first time in India. I know Doug has been here many times, and Jyoti Vinjamar came from Bangalore. But there are, I think it's a wonderful experience for us to be here and to share our thoughts about e-discovery and about artificial intelligence and machine learning, and have a conversation that is not just for today, but going forward. Hopefully at the law school will spur some dialogue. And I want to also thank Ashish Singh at Capstone Legal and his team at Capstone Legal for facilitating this day's conference. It couldn't have gone better in terms of the setup and the preparation, and they did a lot of work behind the scenes. And we'll continue to be working on handouts and put papers up online. And so I encourage everybody to check out the Capstone Legal site for further reference material related to this conference. So today, in the afternoon session, we had listed Connor Crowley, who's going to be here from UBS in Hong Kong, and Connor had surgery and couldn't make it. So I'm sort of filled in a talk here that I cobbled together, and with that, let's see if this works. You who are not in the morning session, and I don't know if I need a microphone for the taping purposes, let me know. Here, we'll go. So for those of you who weren't here this morning, just to set the baseline, set the table, that e-discovery is about discovery, which is in litigation in the United States and elsewhere, that exchange of information or the gathering of information in electronic form that's evidence in a case, that's relevant to a case. So we call it electronically stored information, or ESI. And that's the goal is to find what is relevant, so is to produce it to the tribunal, to the court. We are truth seekers in the US, and we want to get as many documents and as much in electronic form as that is relevant to a case. And so e-discovery is all about that in terms of gathering, collecting, and searching through quantities of electronic data. And now it means much more than it has ever before because of the Internet of Things, we'll talk about. So with that, the slides will be available to everybody, the types of ESI that are out there, I went over this in the morning. It's email, but it's beyond email now. It's every type of electronic source of data that you can think of in your smart homes. It could be smart thermostats. It could be Alexa, who you talk to and is recording, and Amazon and other companies are keeping your voice recordings. And so that's led to litigation demands, e-discovery demands for that kind of data. Databases of all kinds, communication apps of all kinds, and all kinds of legacy devices, especially smartphones and other mobile devices. It's all grist for the possibility of e-discovery. Why is e-discovery important? Well, I woke up this morning at my hotel, and at my door were several newspapers, and I opened them up at breakfast this morning, and here are some headlines from the Bengaluru Express. Drones used for suburban report, conducting aerial surveys. So apparently drone data is increasingly being used in various documents, and we can have a conversation throughout the afternoon about the use of such data and how to collect it, and what it means for potential e-discovery purposes in the future. There was another article in the New Indian Express about city drivers walking away from app-based cab companies. They're losing money, having not been, the promises that were asked and the discounts didn't work. But the important thing for e-discovery purposes is that there are apps on Uber and Lyft and anything that you name, a whole sort of task-driven economy, a gig-driven economy where there are apps that are out there, and those apps contain data, contain interactions, contain ratings, and that could be used for e-discovery purposes. At least in the US it can. In the Weekly Business Standard, there were several articles. One was an article on the Marriott breach. Did everybody know about that? Does people know about
if you've ever stayed at a Starwood hotel, some of us have, and we were at the at the Marriott. I was in Jaipur. In any event, there have been a massive breach of 500 million Marriott guests' data with passport information and all sorts of information. That is increasingly a problem in the world, and we should have a conversation about how there's litigation involving breaches, and there's a need to figure out what happened, and that means tools and techniques that are e-discovery related. And so cyber breach is a very big issue in the world. Another article was about Noida's smartphones under the brand Oppo, 3 million unit sales from July to September. So smartphones are big in India, and I think it's a leveler in some extent because there's been a leapfrog from many people few people have computers in India, but many people now have smartphones, and it's growing in huge amounts. And e-discovery involves electronic evidence that can be found on a smartphone and a device, and so there may be an obligation to produce that in litigation. My favorite article from today's morning paper was something like dystopia. Chinese scientist employs gene editing technology, CRISPR, to edit genomes of embryos. So do you all know about this, that there's a Chinese scientist who's in trouble? And there are actually some other professors that are in trouble in other places in the world because of their use of this technology. What this suggests to me is that when we're at law school, like National Law School, and as lawyers, we need to read the morning paper. We need to understand what kind of use of technology there's out there in all sorts of ways that are almost like science fiction. The idea that we'd have gene-edited babies is science fiction. But I can tell you that if there were professors in the United States doing this, or if a company did something with CRISPR that involved changing genes and it affected a baby, it affected children, there may well be litigation, and there might well be a need to be technologically competent as lawyers to understand what kind of evidence you would need from a gene perspective, from a DNA perspective. And that's a pretty out there example, and I don't mean to suggest that that's going to be part of your future as students and us as lawyers. But the fact is that when I read the newspaper, I'm always thinking of the connection between law and technology. And I'm thinking about how I would search for that electronic evidence. How would I collect it? How would I preserve it if it were part of a lawsuit? And those are questions that we're going to have to ask, whether it's driverless cars in the future or any kind of technology, drones or any kind of smart object. How do we collect the data out of those objects? So it's a question that's way beyond email. I've spent most of my career worrying about White House email in litigation, from Ronald Reagan on to the present. And I should say I just learned of President George H.W. Bush's passing away on the news earlier at the lunch hour, and I want to express my condolences. But the fact is that we are in a world where it's not just email anymore, it's all sorts of electronic stuff. Now, this is a difficult slide to read. All I want to say here about India law is that, first of all, that I understand that in terms of the legal system, there is a close mirror to UK practices in India in many ways in terms of the court system. But the Civil Procedure Code of 1908, I'm not going to be an expert on this, and I defer to people in the room, but I do want to point out that there are elements of the code and of law that has been passed since the code that certainly point in the direction that there's a duty on the part of parties to make discovery on the oath of the documents, and that there is a discovery process that's anticipated in the civil procedure codes. And there are, although the Civil Procedure Case Code does not specifically contemplate or address the discovery of electronic documents, other areas of Indian law have been updated to address electronic documents in court proceedings. So the Information Technology Act of 2000 sets forth laws relating to information technology, and the IT Act has changed the definition of evidence from all documents produced to all documents including electronic records produced for the inspection of the court. And I'm sure if we had the time today, there would be many other laws and statutes that you're all aware of that I'm not including here that anticipate electronic evidence being produced in court. So we can have a conversation about how robust that is and how much of a usual practice is it in Indian courts. But I believe that the law at least is expansive enough to allow for a discovery process that includes electronic records. E-discovery is increasingly important for corporations in India and around the world because of litigation demands coming from the US. Some people in India have been shocked by the burden imposed on them because of US-style e-discovery, so we should talk about that. Cyber forensics on all devices, both in civil matters and criminal matters, to detect to find what's on computers. To detect fraud or anomalies in compliance matters is important. In regulatory matters, it's important to find electronic evidence. And responding to access requests of all types, including coming from US-initiated litigation. I've spent some portion of my career on Freedom of Information Act matters in the United States, and I think it's important to understand what kind of electronic documents exist in archives and public repositories. So e-discovery plays a role in terms of searching that information. Why is e-discovery important? Well, I think what I really should say, which is an obvious point to everyone in this room, is that the global e-discovery market cap is very large. Every major research organization, Gartner, Forrester, and people behind various studies, one has suggested that the market is 17 billion in US dollars by 2023. That means a huge business opportunity, in theory, to not only to participate in document review for purposes of litigation and to use best techniques, but to basically what we would say in the US is to build a better mousetrap. Doug and I were talking about this at dinner the other night, and the question for the audience and for the symposium here today is, are there individuals, smart individuals in India who can find and basically do as well or better than Silicon Valley or other people in the United States and others around in Europe? Can you do better in India to come up with better software that finds electronic evidence efficiently and fast, and you can search all sorts of ways so as to find out what is important in litigation or otherwise. Mobile devices, we've spoken about that this morning. I won't belabor the point, but it's a tremendous exponential rise in them, and so I think it's important not to ignore them. There's also a digital India movement. E-governance is an essential part of our dream of a digital India, and for the Prime Minister saying that. And so he's absolutely right. The more technology we infuse in governance, the better it is for India. But with technology, there comes the potential for lawsuits, and we as lawyers need to sort of step up our game to understand what's out there. There are lots of tools being developed in India, and so I think people recognize the importance of e-discovery. This is an article that I found that said that India's own e-discovery tool to curb cyber crimes is being developed, and I'm sure there are 100 other applications as we speak today that are being developed that are homegrown in India, and that's a good thing. Becoming a savvier lawyer in Indian courts. I had the pleasure of watching Ashish Singh do an oral argument in a company law court in Jaipur earlier this week. There wasn't a whole lot of discussion about e-discovery in the case that you were at, but he was a passionate advocate, and I think he was an example of someone who would be knowledgeable enough to know that in the appropriate case, whether it's an arbitration proceeding or any kind of court in India, he would be able to step forward and say, hey, I have this evidence that supports my case, or that you should produce something in electronic form. And so I'm not sure that all the lawyers in the room could understand that, but I know Ashish does. And so as a matter of professional competence, to understand what we're talking about today, I think it's important across a spectrum of litigation. I work in cases that involve millions, hundreds of millions, or billions of electronic objects. That happened to be my career at the Justice Department and as Director of Litigation at the U.S. National Archives. I worked on big cases, but the kind of conversation we're having in the room today is not just for big cases. It could be for a very small case involving a divorce, where the relevant evidence is on Facebook of who said what to whom, or on WhatsApp, or on Instagram, or some photos of something, or whatever. And that's true of personal injury cases, small commercial disputes, as well as complex matters. And so it's important across any kind of legal practice in India and across the world to understand technology and to understand how to get at it, how to preserve the evidence, and to use it. So there's a strategic advantage for lawyers who, over lawyers, who refuse to understand what the power and significance of digital evidence is. We see it all the time. To the lawyers that don't want to understand what e-discovery is about, what I say to them is, it's time to retire. Okay. So my career has gone from paper to thinking about big data. When I started, it was all boxes, and it's now virtually all electronic evidence of the important evidence in lawsuits. I don't know how many people have been to the Czech Republic. Has there anybody been here in this room to Prague? My U.S. colleagues, anybody? Ah, there are. Okay, this is my favorite city. I think Jaipur might be up there too. But in Prague there is a castle by the Charles Bridge, and the reason I put this slide up is that this is a problem for the United States, a problem for India, a problem for any complex organization, which is that nobody knows where the electronic evidence is. And it's just like being in a castle in Prague where there are hundreds of rooms. And in corporations, if you have a big corporation, a Fortune 500 corporation, a US corporation in India, or an India corporation, there might be 500 different email systems and other legacy systems and backup tapes and all sorts of ways that data is stored on mobile devices, on networks, on servers. It's like having rooms in a castle, and nobody knows where everything is in a castle, and nobody knows where all the data is. So I like putting up the slide of Prague, and I really like Prague because it's the home of Franz Kafka, who, for me, is the patron saint of the U.S. government policy in Washington these days. Anyway, so that part of the tape is going to get cut out by Ashish before we put it up online. Okay. All right. Then the one important matter about e-discovery is that we are thinking about the future. The question was raised in the morning session about the future of e-discovery, and we'll get back to it. But one of the problems, and I spoke to a bunch of journalists earlier this week in Jaipur, is that they were all about privacy and legislation that is pending in India and the Data Protection Act. We are looking at a world of surveillance, of the ability of corporations to look at our data and governments to look at our data. And so we as lawyers need to know how to push back and to help individuals fight back when appropriate. If your data protection law is passed, there may well be a conversation that lawyers have with people who want to have their evidence, have their data erased from big corporations in America or around the world. And so knowing something about e-discovery, knowing something about electronic evidence is really important when we're thinking about a surveillance society. We as lawyers have a unique skill set. In the United States, I've been very privileged to work with the very best lawyers, some of whom are here, to think about how to advance the law, to have guidelines and principles in place so that lawyers and courts know what they're doing when they're talking about e-discovery. And we, as lawyers, I think have a responsibility to be leaders in this, in wherever we go, whether we're part of corporations or we're representing individuals. That's why I've spent time for the last 5 years in private practice at Drinker Biddle to take what I learned about e-discovery and apply it to what is this new emerging field in the U.S. called information governance. And I'm not going to stand here for more than just one more minute and talk about it, but the field is one where you're thinking about holistically about data in corporations, data in organizations, data in public agencies, how to manage it, how to preserve it, how to make it accessible, how to deal with privacy concerns, how to deal with security concerns with cyber breach. And so there's some of us who've been sort of standing on a soapbox and using the tools of e-discovery that we've learned to talk to corporations as our clients about broader issues, about governance generally. So it's lessons learned. What is information governance? It's not information management. Information management is how stuff flows through an enterprise, IG, information governance, is why you have information in the first place. So you sort of step back and you have a conversation with your client about what exactly is going on. And there is a need because we operate in an increasingly complex environment. We have volumes of data that are overwhelming. And it's important for all organizations, private and public, to balance the value of the data they hold and the risks and costs of continuing to store it. So part of that is organizations need to continue to meet legal requirements when making decisions. It remains important to take a holistic view. So if e-discovery is part of a larger world that I at least practice in, my clients want me to advise them about big data and about using artificial intelligence, not just for litigation, but to manage the records and manage the information that they have in a smarter way, to get rid of stuff that needs to be deleted and to preserve stuff for legal holds or for preservation purposes. So that's the kind of conversation I have. I'm going to go past that slide. I'll just say that culture change is possible. It's possible in the US and it's possible in India. And I really believe that. And I think Doug has emphasized the need for people to be involved. You can have all the tools you need in e-discovery, but you need to understand how to use those tools. And that's part of culture change in lawyers, to get more technical, to get more savvy about technology. And so we can stay in our lane, we can stay sort of putting our heads in the sand about technology, or we can embrace technology. We can have law schools have courses about e-discovery, which I would encourage in India. There are many law schools in the United States with courses. I did promise Ashish that I would give a book that I edited on the topic to the law school. So I will do that at the end of the day. I encourage people to go out and take a look at this book. Those of you who are representing corporations or solution providers in the space. I get no royalties from this book, so I'm not making any money on it. But I did think it's a book that's 600 pages, all about the advanced search methods that we're talking about at the conference today. So I think I've given you some ideas about why I think that e-discovery is having an impact around the world, and it's important for India. And I thank you.